Good communication, it's critical. If you want to maintain a good practice, you want to make sure that you have procedures in place so that to ensure that you are able to adequately communicate with your client. Because AI, unfortunately, is gaining a lot of traction in the ethics and discipline world. AI is really an ethical minefield. But if you want to actually do legal research and writing, it is fraught with peril. A misappropriation is any time a lawyer kind of helps themselves to entrusted funds. All right. It's the unauthorized use of entrusted funds, even if it's the temporary use.
Welcome, and thank you for joining us for another Justia webinar. My name is Nina, and I'll be the moderator for today. Now, to kick things off, I want to go ahead and introduce our speaker, the Honorable Dolores Dorsa-Enville. Judge Dorsa-Enville was appointed as a judge to the District Court of Prince George's County, Maryland on February 17, 2020. Judge Dorsa-Enville presides over trials and issues decisions in numerous cases, including civil lawsuits, criminal misdemeanors and certain felonies, domestic violence matters, tax, motor vehicle violations, landlord-tenant disputes, and more. She is also reviews search warrants and issues decisions regarding expungements, shielding, garnishments, statutory exemptions, and motions filed before and after civil and criminal trials in Prince George's County, Maryland. The webinar that you're about to watch will be approximately 1 hour, and Judge Dorsa-Enville will be taking questions once we are done with the presentation. So if you have any questions that come up, please be sure to submit those by clicking the Q&A button in the control panel at the bottom of your screen and submitting them there. Now, without further ado, here is Judge Dorsa-Enville to discuss hot topics in legal ethics, from AI to client communication and everything in between.
Thank you, Nina. I appreciate that. Good afternoon, everyone. I'm going to start to talk about a number of issues today. So this is titled Hot Topics. So it's going to be kind of a mix of a couple of different, what I think are probably the more important rules of professional conduct. So today, for purposes of today's discussion, we're only going to focus on the ABA model rules. We're not going to look at the specific jurisdictions, but I would certainly encourage you to look at your jurisdiction's specific rules so that you understand, since they're all kind of nuanced. All right, so welcome. We're here. Again, this presentation, this is just for educational purposes. I'm not here to give legal advice. I'm not here to tell you as a jurist how it is that I would rule in a particular matter. I'm simply here to share with you knowledge that I have about the rules of professional conduct, since I've had a lengthy career prosecuting lawyers for ethical misconduct. I consider myself an ethicist. I love to teach on the topic of legal ethics, and I think this is probably one of the more worthwhile kind of CLEs that you can have, because this is the kind of information that you'll get that will protect your license. All right, so just our course objectives. We're going to go over, the rules that Nina has laid out, the 1.4 client communication, fee agreements. We're going to talk about trust accounts, since that is probably one of the most important rules that you're going to learn about. And then we're going to dovetail into artificial intelligence, since that is becoming, unfortunately, a trend that we're seeing with regard to attorney discipline cases. And then I think with each individual area, I do have best practices, but at the very end, we do have best practices overall for avoiding grievances and some reference materials. So we'll first start. The most common rule violation, if you can guess, is Rule 1.4, failing to communicate. When we talk about kind of the cases that we see, and I say we, I'm talking as if I'm still working for disciplinary counsel. I am now a judge. But I will say that the cases that disciplinary counsel sees typically tend to deal with failing to communicate. All right, so that's a failure of 1.4. The neglect cases, those are found in Article 1. That's the failing to communicate, failing to be competent, failing to be diligent. And I would say that the bulk of attorney grievance work, that's the healthy playground, if you will, for those rule violations. So some of the things that you should note with regard to your obligation, you want to make sure that it's important to communicate with your client. The practice of law, I mean, it's an honorable profession, but it's also a business. Okay. So for those of you that are actually out there practicing, whether it is, through your own practice, because you've hung out a shingle, if you're solo, if you're working in a law firm, if you're working for a government entity, wherever it is that you're working, it is critically important that you maintain adequate communication with your client. I've found through my work with disciplinary counsel is that at the heart of many of the complaints that would come through, typically it came through because clients felt like they could not get a hold of their lawyers. And so, that's important because it's affecting your practice. You want to make sure that you understand your duty. Rule 1.4, that's the rule that deals with communication. It requires transmission of prompt information to the client. Additionally, there's a requirement that you comply promptly with reasonable requests for information. So if a client comes to you and they want to know, hey, what's going on with my matter, it's important that a lawyer kind of put aside what it is they're doing so that they can make sure that they're promptly responding to those requests. Good communication, it's critical. If you want to maintain a good practice, you want to make sure that you have procedures in place so that to ensure that you are able to adequately communicate with your client. There are some ways to do that. Initially, I think at the very outset of the client meeting, you should let the client know what you consider to be reasonable. Okay. And every case is different. Every scenario has its own kind of facts and circumstances, which will lend to what one would consider reasonable or prompt communication. If you are in the midst of active litigation, if there is a court hearing set for, within the week or within a few days, it may not be adequate to talk to your client for the first time the morning of. Okay. It may not be considered adequate to talk to your client, minutes before, they're about to take the witness stand. If it's a protracted litigation or if it's a matter where there isn't anything necessarily pressing, there's not a statute of limitations or anything that's pending, it still may not be considered adequate to talk to your client within a week or two, or maybe even a month. But what I would suggest is the best thing to do is to temper your client's expectations and do that early. You do that during the initial meeting. Okay. So at the initial outset, you should tell your client what it is that they can expect in terms of communicating with you. Now, some lawyers have developed practices whereby they talk to their clients via text. And, with technology and kind of how technology has grown and changed the practice of law, that might be considered okay. I, of course, would never suggest that a lawyer communicate with their client via text for a couple of reasons. I think text messaging tends to be a little bit too informal in nature. And then you also have to temper your client's expectations with regard to how to receive messages on text. Now, you and I know that if you text a friend or a partner or family member, typically you expect a response soon. And soon could be, within the hour or within that day. It's important to remember clients also would expect the same thing if they're communicating with you via text. It may not be okay to respond to a text message within 24 to 48 hours. All right. It really just depends on the circumstance, but I share that so that that just gives you some food for thought with regard to how you set up your practice. Additionally, it's also a great idea to develop form letters. So based on your practice, whatever it is that you're doing, it's great if you just have a form letter. And every time something happens in the case, you can simply send out the letter. And now with email, I mean, a lot of clients and attorneys are communicating via electronic mail. You can attach a letter or an email itself and just send it off to the client just to let them know what it is that's happening in their case. It could be something as simple as, filed your case today in circuit court. We should expect something within a month. Or right now we're in the discovery phase. We've sent out discovery. We're waiting on a response. Anything sort of, in that nature. Additionally, anytime you're doing something important for a client or you're you want to get their input on something. It's something that they have to decide whether they want to accept the settlement, whether they want to testify and take the stand in a criminal trial, anything that's really very important. You want to make sure that you memorialize that in writing so that you and the client are both on the same page. And what I would suggest, following a conversation with your client, you simply memorialize that conversation and say, as per our meeting today, you have told me that would like for me to pursue your matter by doing X, Y, and Z, or reaching out to the other party and making said settlement offer. I mean, whatever it is. Putting important things like that in writing are crucial. They're critical because oftentimes what happens is, following like an important meeting like that, the client may either misremember or not necessarily understand how it is that the parties left the meeting. And in which case, if they believe that you've taken some action that you weren't authorized to take, you can simply point to the letter that you've written, memorializing your conversation, whereby you said, this is what you've asked me to do. And in which case, client would be hard pressed to say, well, that's not true if there's a letter that's memorializing that. So that's just kind of a good thing to do. Other best practices, of course, always timely respond to clients, whether it's their phone call or their email. And what I would suggest is that you should put in your retainer agreement what that time frame will look like. So whatever it is that you've determined is reasonable, your practice could mean 24 hours, could be 72 hours. Put it in your retainer agreement so that the client is on notice. Because when they sign your retainer agreement, they'll know this lawyer will tend to get back to me within a day or two. So they won't be, they won't be worried in the event that they don't hear from you. Another thing you can do, you can send your client everything that relates to the representation. Anytime you file something, anytime you send something to opposing counsel, anytime you take any action whatsoever, the best thing to do really is to carbon copy the client. You can CC them on that letter so that they'll know and they'll get a copy of that. And essentially what will happen is that client, they'll have their own file at home, and that file really should be identical to what you have in your file in your office. All right. You can memorialize, memos to the file, the phone calls we talked about, or the in-person meetings. All of that can be memorialized. The client should get a copy, and in which case they should have their own working file with all of the information outside of your work product, of course. Show your time in timesheets. Some lawyers have to keep their time based on, what it is that they're doing for the client. Show your client what you're doing based on what you're indicating in your timesheet. And part of that should indicate communications with the client. It's always a good idea to develop a good case strategy. You want to make sure that you build in adequate time, of course, to prepare, for your motions and that sort of thing. And that kind of dovetails a little bit into 1.3. But when we talk about client communication, you also want to make sure that you're mindful of vulnerable clients. And I say vulnerable because you may find yourself representing a client who either there might be a language barrier. Okay, they might speak a language that you don't speak. They might have some mental incapacity. They might have some physical incapacity. There could be some sort of incapacity whereby you two may not always be on the same page, in which case, as the lawyer, you have to determine how it is that you're going to have that reasonable communication. That could mean hiring an interpreter or hiring someone so that you can interface with your client to make sure that they understand what it is that they've been hired to do and what it is that you're going to do on their behalf. All right, so now we're going to move into Rule 1.5. 1.5 deals with fees. 1.5AA, of course, dictates that lawyers' fees have to be reasonable. There are about 8 different factors that are taken into place to determine what is considered reasonable. All right, certain things such as the time and the labor that's required for representation, the likelihood that the lawyer has to kind of turn down other work, if you will, the novelty, the skill set that's required for that work, the time limitations that might be imposed by taking on that representation, the nature, the length of the professional relationship with the client, the lawyer's experience, their reputation, their expertise, Additionally, what's customary in that area? What do other lawyers charge to take on that same sort of work? So, you want to make sure that when you're drafting your retainer agreement, that the fee that you are quoting your client is commensurate with, what other practitioners are doing. Now, there are circumstances where some lawyers are deemed experts, if you will, and their fee may be way higher than anything you might see in that area. That's okay too, so long as they can substantiate that. Okay. Rule 1.5b talks about the scope and basis for the representation. So that essentially is where the fee agreements are found. Some jurisdictions require that lawyers put in writing what the scope of the representation is. Essentially, that means, what did the client hire you to do? Okay. And what did you agree to do on behalf of the client? The basis, that's essentially the fee. Whatever your fee is, and we're going to talk about fees in a second, but whatever your fee is, it should be memorialized in this 1.5b document, your fee agreement. 1.5c allows for contingency agreements if that's, the nature of your work. 1.5d, those are prohibited fees. So lawyers are prohibited from taking contingency fees in domestic cases as well as criminal cases for a host of reasons, if you can imagine. But certainly public policy reasons with regard to, custody, divorce. Lawyers should not be getting a portion of, monies that should be deemed for child support or alimony, that sort of thing. And 1.5e talks about division of fees. This is when lawyers who are not in the same firm but are associated with each other with regard to this, the particular representation. How do they divide those fees? All right. And 1.5e sets forth that lawyers are able to do that so long as each lawyer assumes joint responsibility for the overall representation. The client, of course, has to agree to that arrangement, and the total fee is reasonable. So it can't just be two lawyers collecting two whole fees, but really a whole fee that's split in half or whatever portion thereof. All right, so some things you want to be mindful of when we talk about fee agreements. It's a legally binding contract. So it's always a good idea to make sure that you've had that 1.4 adequate communication discussion with your client so that they understand what your expectations are for getting paid. And they will know, and you will know, what it is that they've hired you to do. It's important to be candid during this billing discussion. You don't want a situation where you're billing your client and they receive your bill and they get what we call sticker shock, where they say, oh my God, I had no clue. I would even say it's a good idea to kind of let the client know roundabouts what they can expect in terms of how much a representation costs. If you think a representation for a family law case will cost them upwards of $20 or $30 or $40,000, that's something you should tell them initially. Because some persons may walk in thinking, my Uncle Jed told me that his divorce cost $4,000, so I'm thinking mine should cost around what his costs. But as we all know, each case is different. Each case turns on its own set of unique facts, so you want to make sure that you avoid that sticker shock. Additionally, when we talk about fee agreements, you want to make sure that you explain policies that you may have or penalties for late payments, okay? Whatever those policies are, make sure they comply with local laws. Okay. You can't kind of expect or charge you serious fees since that will violate state laws. So just make sure that the client knows anytime that you pay me late, there's a late fee of X that will be tacked on. Additionally, and I share this because I think at the heart of many of the bar complaints that I've seen over the course of 15 years, many of them are fee disputes. Okay. And if you do consumer-based type of practice, like if you're, doing litigation, either like bankruptcy or family law, personal injury, real estate, I mean, those are tort law, those are all kind of fraught with issues when it comes to fee disputes. So if you are able to resolve it, and you are able to have an ironclad fee agreement, you are taking to heart your 1.4 obligations with regard to discussions with your client about the fee agreement, you probably will be subject less to bar complaints. Like I said, at the heart of many of the bar complaints that I've seen over the course of 15 years, many of them dealt with fee disputes. So if you are in kind of a litigation, consumer-based type of practice area, think about how it is that you are going to deal with collecting fees. If your first initial reaction is to file a lawsuit against your client, um, although you certainly can do it, it just might not be good for practice, your business. You want to think about things that you can do, perhaps using a local bar association. Many bar associations have fee dispute programs. You can perhaps use a collection agency. Anything short of litigation, I think, only because, like I said, the practice of law, it's a business. And so you don't want to be the lawyer that is constantly bringing their clients into court to sue for fees, because it kind of screams that there might be some other issue. It might be a 1.4 issue going on as well. So these are kind of essential provisions for fee agreements. And I'm sure there are more, but these are some of the things that you may want to think about including in your fee agreement. I've seen fee agreements as, as lengthy as 20 pages. I've seen fee agreements as short as 1 page. There is not a one size fits all when it comes to fee agreements. But I will say, whatever it is that you put in there, you just have to make sure that you are using plain English. And also you take into account the sophistication level of your client. If you're representing Fortune 500 companies, having the legal jargon in there, that more than likely may be okay. But if you are representing an everyday average citizen, having a bunch of legalese in there may not inure to your benefit, only because you want to make sure that the client who's signing off on this fee agreement understands what it is that they're reading. So these are some of the things that I think are good provisions to include. Of course, the scope of the representation, that's the 1.5B. It should be dated. The fee amount, whether it's a deposit or retainer, and we'll talk about that shortly. Who's the client? There's some situations where the person who's paying the fee is not the client. It could be the parents of a person. It could be the estate of a person. It could be a number of different things, but you want to make sure that it is spelled out very clearly who the lawyer is going to represent. If there are service fees, if there are other fees, such as expert witness fees, investigator fees, court reporting fees, you want to make sure that it's spelled out who is responsible for paying those fees. That kind of ties in with its expenses. Does the lawyer handle the expenses on the front end? Is that something that's reimbursed to the lawyer, or is that an expense that the client has to bear initially? All of that should be spelled out. Fee disputes, we talked about that. Late payments, notice. The client should have the attorney's address. The attorney should have the client's address. And there should be a provision in the event that the client moves, relocates, or what have you. There should be a way that the lawyer can get in touch with the client. I've seen many cases where clients kind of disappear and lawyers are stuck and not sure what to do, especially if there's something pending that's imminent, like a court date or, something along those nature. So you want to make sure that whatever it is that the client provides some information on how to reach them. It could be an email, could be a family member's phone number or address, something, so that the lawyer has a means for which to maintain that contact. Also, your billing cycle. I think that this is really important because the client wants to know, how often are you billing? If you are billing, every 2 weeks, that should be noted. If you're billing on a monthly basis, I think most attorneys probably bill on a monthly basis. But whatever it is, just spell it out for the client so they're not surprised when they get that communication from you. All right, so some states require a written fee agreement. States like Arizona, Colorado, District of Columbia, Montana, New Jersey, Pennsylvania, Rhode Island, Wisconsin. I'm sure there are others. There are other jurisdictions where it's not necessarily required, like Maryland. But whatever it is, I think it's always a good idea to have something in writing. That way there's no confusion as to what it is that the parties agreed upon on the date they agreed upon. All right, so fees, there are different kind of fees, all right? You could be charging on an hourly basis, and that just is the number of hours that you're working times whatever your hourly rate is. There's a blended rate, so different hourly rates based on the staff level. You might charge differently for your associate or paralegal's time, what have you. Just make sure that that's listed somewhere in your fee agreement. If you're working on a contingency fee, whereby you're taking a percentage of the overall outcome, if you will, that should be clearly stated, whatever that percentage is. If it's 25%, if it's a third, if it's 40% after you filed a lawsuit, whatever it is, the client needs to know what that percentage is. I don't really see value billing a lot, but sometimes lawyers do higher billing if the attorneys are able to achieve a favorable result. Engagement retainers. Engagement retainers really are for the attorney's availability. So really, it's just an availability retainer, which means once the lawyer's paid that engagement retainer, it's theirs to keep. All right. Engagement retainers are very rare. There are other fees that are set by statute, like probate fees or Social Security. Those are set by law. So again, that should just all be included in the agreement itself so the client knows what that rate is. There are also flat fees. Flat fee just means fixed fee. It means one flat rate for all of the work that the lawyer intends to do. All right, so flat fees, again, it's for all the work. It's one rate that the lawyer is going to charge for that particular matter. I gave an example here, a contract review. Sometimes lawyers might charge, hypothetically, $1,000 to review a contract. And so they can indicate that their flat rate is that $1,000. A flat rate that's paid at the outset, meaning if it's paid at the outset, it means that the lawyer still has to do the work, okay? It's only earned after the lawyer has actually completed the work. So with flat fees, timing is key, okay? There's a case that came out in the District of Columbia in Ray Mance. It's a case of first impression in the District of Columbia. And essentially, it set the criminal bar and the bar that handles flat fee, probably like the immigration bar, some of the domestic lawyers as well. It turned the bar on its head because this was the first time the Court of Appeals came out and said definitively that flat fees are not earned upon receipt. All right. A lawyer has to actually do the work in order to earn that fee. So if you are collecting a flat fee at the outset, you have to determine what your markers are going to be with regard to how it is that you earn portions of that fee. It's not okay to say, well, I've consulted with the client. We had an in-person consult, and they paid me the fee. Therefore, it's considered earned. That's what they consider front loading. That's prohibited under case law. So you have to make sure that you understand the difference. So engagement fees versus advanced fees. Again, engagement fees really are just for the lawyer's availability. If you need, let's say, a very popular lawyer to represent you, you have to typically pay an availability retainer just to make sure that they're available in the event that they need you. And let's say you now need them, you then have to sign off on an engagement retainer, meaning like a fee agreement whereby they tell you what their either hourly rate or flat fee rate is. So that'll be two different retainers for that one lawyer. Like I said before, engagement fees are extremely, extremely rare. This is for the best of the best in the legal profession. If you're kind of new to the practice of law or just been practicing a few years, I haven't seen very many engagement fee retainers just for a lawyer to be available to do the work, okay? So you want to make sure that you don't run afoul of the rules by calling your fee agreement an engagement fee, because if you intend to do the work at the point in time that the client has retained you, that's not an engagement fee. That's a regular retainer, okay? And I've seen lawyers in an effort to get around the case in Ray Mance, kind of title their fees in different ways so that they can consider that earned upon receipt. And again, this all kind of runs afoul of the rules. And I share this because it's particularly important, because when we talk about fees and money, there's that fiduciary responsibility that is so important that if you violate that fiduciary responsibility, you could be disbarred. All right. So that's why I want to make sure that lawyers don't find themselves in a situation where they're trying to play fast and loose and calling a regular fee or an advance fee an engagement fee. And so an advance fee, like I said here, the difference, it's a prepayment for future legal services. So if a client comes in and says, I want to retain you, and you say, okay, and you're available for the work, that's an advance fee. All right. And they'll pay you whatever it is that you're requiring up front. And those funds typically have to go into the attorney trust account or an IOLTA account. IOLTA in the District of Columbia in Maryland just stands for Interest on Lawyers Trust Account. They're all interchangeable, but whatever your jurisdiction calls it, that's the account. It's essentially the trust account where entrusted funds go. All right, so I have this here, some examples for what we consider illegal fees. Illegal fees, essentially, they're ones that kind of violate statute or case law. I've seen retainer agreements that talk about non-refundable retainers. Non-refundable equals illegal, okay? Several jurisdictions, including Colorado, the District of Columbia, have come out and said a lawyer can't earn a fee for doing nothing. Same thing in Maryland. A lawyer who's engaged to do work actually has to do the work. You can't call an engagement fee a non-refundable, you can't call an advance fee a non-refundable fee in an effort to have it be an engagement fee. And like I said, I cited the In re Mance case again. And this was the case because I'm telling you, before 2009, lawyers considered flat fees earned upon receipt. And so when this case came out, it essentially stopped that practice altogether so that lawyers were held accountable so that they can make sure that they comply with Rule 1.15 to make sure that the client understands what portion is considered earned. And so following Mance, there were a legal ethics opinion that essentially came out. The Sather case in Colorado came out, and it basically talked about markers that an attorney can have to indicate the time period for when the time period for when they can consider certain fees earned. So, for example, if you have been retained to represent a client during a litigation, certainly, let's say litigation is typically, 3 areas: pre-litigation, which might include, discovery, the attorney doing some due diligence, fact finding, the litigation itself, that could be the court hearing, any motions practice, and then the third aspect could be, an appeal, depending on the level of work you do. And in which case, or it could be sentencing. Let's say it's a criminal matter, and you've agreed to represent the client through sentencing. So those 3 things, after the completion of each one of those things, could mean that the lawyer could take a third of what was already paid with regard to the flat fee. So that's just an example. The marker could be based on the passage of time, okay? So if a client's hired you, you can say in your retainer agreement, after 60 days or after 90 days, I will be entitled to collect a third. After another 90 days, another third. It could just be based on a number of things, but whatever it is, you want to make sure that you kind of clearly state that. All right, so some examples of unreasonable fees. Changing the hourly rate. I've seen cases where lawyers change hourly rates during the course of the representation without giving proper notice to the client. Typically, if that's something you're going to do, I would suggest don't do it in the midst of the representation. You might want to think about starting that hourly rate change at the start of a new client. But if you are going to do that during the course of the representation, it might be a great idea to just have the client come in, sit down, talk to them. Let them know what it is that you intend to do. Have that new fee agreement. It could be a revised or amended, and have them sign off on that so that there's no confusion that the hourly rate or the new hourly rate will take effect, and they are essentially conceding that. Gouging clients, drumming up unnecessary high fees, that's all considered unreasonable. Lawyer charging interest on an unpaid balance is the case out of Michigan, grievance administrator versus Mark Hamilton. Front loading, I talked about that briefly, but the DC Legal Ethics Opinion 355, if you're able, you can access that online, but it's a great opinion because it really kind of lays out all the considerations that lawyers who do flat fee work, they want to consider. Front loading essentially meaning that the clients come in, you've charged them the fee, the flat fee. You haven't started work yet outside of the consult, but you've determined that all of the fee is deemed earned upon that initial meeting. That's considered front loading. That's prohibited by case law. There's several cases that have come out and said that lawyers can't do that. You actually have to do some level of work so that you can collect. And some lawyers, their practice is to just collect the full amount at the very end of the representation. And truthfully, I don't think you can go wrong with that. If anything, that's probably one of the best practices. That way, there's no confusion. A client can't come and say, well, you didn't do X, Y, and Z. And I was expecting that you did this before you got paid that. And, you don't have to do all the back and forth. So some practical advice when we talk about fee agreements: don't wing it. Don't ever rely on your recollection or the client's recollection. Simply memorialize it, put it in writing. Don't ever brush the client's concerns under the rug. If they come to you with concerns, whether it's valid or, may have merit or not, sit down, address it head on. And again, following that meeting where, you've kind of cleared up any confusion, memorialize it. Okay. Don't ever brush their concerns under the rug. Additionally, don't be afraid to ask other attorneys for advice. Many of you know other attorneys who may be in your practice area. Some of you may be members of bar associations. It's always a good idea just to talk to other practitioners who do what you do, or they may be doing something you want to do. And, you may want to talk to them about, the best way to kind of get into that niche practice or that area. But it's always a good idea to just ask them for advice and ask, well, how do you handle this? Especially if it's a practitioner that's been practicing a long time, that is, very well respected in your local area. Fee agreements. Don't ever stop revising and fine tuning your agreement. Like I said, I've seen some really great retainer agreements that were 1 page long. I think lawyers, unfortunately, think that the longer the retainer agreement, the better it is. That's not necessarily the case. And again, when you're taking into consideration the sophistication level of your client, you may not need a retainer agreement that's 20 pages long. Some are so succinct that they can say everything they need to say in a few paragraphs. Could be just a few pages. But whatever it is, I would suggest that every year you just take a minute and just look at your retainer agreement to see if it's adequate. Does it address all of your needs, all of your clients' concerns? Think about some of the issues you've had within the past year as it pertains to your fee agreement, and think to yourself, is there a way this document could be better? And in which case, if so, take a moment to revise it. And I know some bar associations or attorney grievance commissions, they'll look at your retainer agreement and let you know if it's adequate and if it has all the information that's requested or required under Rule 1.5b. So you may want to consider doing that as well. All right, so what kind of trouble are lawyers getting into? All right, so we talked about this briefly, but the fast track to disbarment is misappropriation. So misappropriation, that's Rule 1.15a. Commingling is also 1.15a. Those are not they're terms of art. They're not mentioned anywhere, not within the model rules. Some of your individual jurisdictions may have that, but it's essentially a term of art. Misappropriation is any time a lawyer kind of helps themselves to entrusted funds. All right. It's the unauthorized use of entrusted funds, even if it's the temporary use. Because some lawyers think, well, I'll just, borrow from this account, and as soon as I get this settlement money in, I can just put it back. Even the temporary conversion or misappropriation is considered a serious charge because it's being used without the authorization of the client, and it's being used for the lawyer's own personal benefit. All right. And so different jurisdictions look at it. There's intentional misappropriation, there's reckless misappropriation, meaning essentially that you are just not keeping adequate track of what's going on in your attorney trust account, and in which case they're all disbarable offenses. Okay, so whether you've engaged in intentional or reckless, it's all conversion. Conversion is just a nicer way of saying theft. But if you're stealing client funds, even temporarily, and sometimes this comes up because attorney trust accounts are overdrawn. An attorney trust account should never be overdrawn under any circumstance. If that's happening, you have a really serious problem. If you've been convicted of a crime, that too also, that will warrant disbarment. If you're not candid to the tribunal, that's under Rule 3.3, that's problematic as well, because the lawyer's duty to the tribunal really trumps that of their duty to the client. So in some situations, lawyers who lie to the court, who lie in pleadings, who make dishonest statements, they are subject to disbarment. All right, Nina, I do see there are questions. Are we holding them for the end?
If you'd like to take them now, you certainly can. It's up to you, Dolores.
Okay, sure. So I'll just look at the first one. Can a lawyer charge a new client a retainer fee to their trust account simply for reading through emails and texts without ever going to court? Oh, yeah, absolutely. I mean, whatever the nature of your work is. If it's for case review, I mean, whatever it's for, you can charge a client a fee. There's nothing in the rules that say attorneys have to work for free. You should always get paid for your work. So yes, I just mentioned litigation examples, I guess, because I'm a judge. So I'm in court every day. And so a lot of the things I see just are court related. But certainly, you can certainly charge a client for doing a case review just to see if they might have some sort of cause of action or legal action. Additionally, and I don't see the first part of the second question. I think it means, can a lawyer charge for 1 hour initial consult over a video meeting? Again, absolutely. A lawyer can charge for their time, okay? So long as the lawyer is lawyering, meaning you are critically looking at, the facts that are being presented to you. You're thinking about strategies. You are, consulting with the law. Anytime you're doing any lawyering, you certainly can charge. If the consult is by video, if it's in person, if it's by telephone, whatever it is, you can certainly charge for your time. So good question. All right, so what are complete records? I'm sorry, I skipped a slide. So trust account records, back to rule 1.15, what are you required to keep? So 1.15, and this is probably the DC rule 1.15, but I would bet that in your jurisdiction, you are required to keep complete records. Complete records are basically everything that tells the full story of what happened between you and your client. How long are lawyers required to keep trust account records or records generally? Here's the thing. There is no statute of limitations for attorney discipline or grievance complaints. So if you are subject to a complaint, it could be 5 years after the representation, could be 10 years. I would say that it's probably safest to keep your records. Now, I'm not saying that you have to have a warehouse somewhere with all this paper and, the practice of law has kind of moved away from paper, but certainly you should have somewhere online that's safe and secure where you can access information about any client representation from, I'm not going to say the beginning of time, but, a reasonable amount of time. In DC is for a period of 5 years after the termination of the representation. So 5 years from the point in time that you have concluded a matter, you need to keep those records. And every jurisdiction is different, but I just share that to say that there is no statute of limitations for discipline work or, ethics grievances. So you just want to make sure you keep that in mind. Is it ever safe to destroy trust account records when there's no statute? I don't think so. But here's the thing. Many of the banking institutions you have a way that you can access those records. If they don't, I would implore you to talk to your bank and see how it is that you can go about accessing older records. They should have a way, okay? But you want to make sure that you know what that way is. What are considered complete records? Like I said, it's basically, it gives the full story of the representation. So complete records can include not just the bank statements, but it can include copies of receipts. It can include invoices, canceled checks, deposit slips. It can include expenses, receipts, invoices from other providers that are working in connection with the lawyer for that representation. It can include the client file itself. The client file will show what it is that the lawyer did. It'll have the lawyer's timesheet. How much time did they spend on a matter? What did they do for the client in the matter? So there's a case in Ray Donald Clower that's out of the District of Columbia, but essentially it gives a great definition for what complete records are. And essentially, the idea is if Bar Counsel can't figure it out from the records that you've provided, then your records are not complete. Because Bar Counsel should be able to look at your records, and that will include all the records I just indicated, and they should be able to have a full picture as to what occurred during that representation. All right. So now we're going to talk about managing money. Ooh. All right. Trust account versus personal versus operating. Like I said before, when we talk about fees, it's really all just about the timing. If it's an advance fee that has to go into your IOLTA or your attorney trust account, in Maryland, it's called like the client trust fund account. But essentially, it's the account where your trust funds are held. Okay. If it's advance, you deposit the money, then you perform the work. Okay. And under your fee agreement will set forth what the milestones are, what the markers are for when you can get paid. All right. You move those funds from your IOLTA to your operating or your personal account. If the client disputes that amount, what happens is under Rule 1.15 D, I believe, you have to move that back to your trust account, okay, until the dispute is resolved. Now, some lawyers say, well, they disputed this, but it's meritless. And, I've already determined based on what my fee agreement says, I'm entitled. Here's the thing. Even if it lacks merit, it's not up to you to decide that it lacks merit and you keep the money. You still have to move it to the IOLTA. It doesn't really matter whether the dispute is bona fide or not. So long as there's a dispute and the client tells you, hey, I have an issue with you paying yourself this third because whatever the reason, I was expecting more, or I didn't like what happened at trial, or, I'm disappointed with the settlement and I was hoping for X, Y, and Z, whatever it is. All right. It's up to the lawyer to determine how it is that they're going to resolve that. And there are different ways. You can go to mediation and mediate that fee dispute. You can pay it into the court registry, file something with the court, let the court decide. You can go to arbitration. Like I said before, lots of bar associations have fee dispute arbitrations, and you can go before an arbitration board and have them decide, what fees are deemed earned or not. If it's already earned, meaning you've already performed the work and they pay you, then you deposit that straight to your operating. That should never go into your trust account. I know some lawyers like to have that trail. That trail is considered commingling. Commingling is when you mix funds of entrusted funds, and entrusted funds essentially are funds that belong to the client or third party. If you mix that with the lawyer's funds, that's commingling. Commingling can earn you a 6-month suspension. Okay, it essentially will result in a suspension. So you're going to make sure that you never, at any point in time, commingle earned funds with client funds. All right, so this is just another PowerPoint, another slide on complete records, but we talked about that, the Ray Clower case. Where does the money go? So essentially, like I said before, it goes in IOLTA directly if you've already done the work, okay? If you've done the work, send the invoice to the client, they pay you, it goes into IOLTA or trust. If they pay you, you haven't done the work, it goes into operating until you do, excuse me, I messed that up. If you've already done the work, it goes into operating. If you have not done the work, it goes into trust. My apologies, I do not want to confuse you, okay? All right, so again, this just goes back to timing. We talked about the man's case. Like I said, that's just a flat fee, which is considered an advance fee. That has to go into trust until it's earned. I'm now going to switch gears to AI, because AI, unfortunately, is gaining a lot of traction in the ethics and discipline world. AI, it's a fantastic tool. It's great. However, lawyers who think that they're going to use AI in their practice need to really be very careful. You want to make sure, because I think AI is really an ethical minefield. It's great for a lot of things. If you want to get some ideas on what to do for dinner, if you want some ideas on, how to draft a letter to your daughter's teacher, fantastic. But if you want to actually do legal research and writing, it is fraught with peril. And so you want to make sure that the platform that you're using um, is consistent with your obligations under the rules. So here are just a couple of questions that have come out since, the use of AI in the legal practice. Can a lawyer perform his or her professional responsibilities competently when they don't understand how the technology works? I don't think you can. All right. Rule 1.1, and we'll talk about that shortly, has an obligation, an affirmative obligation to lawyers to understand how technology works. Is the bot practicing law? Yeah. Yeah. And we've heard, some of the cases that you're seeing in the news. I mean, those are the worst offenders. But I think that more and more lawyers are using AI. They're not necessarily using it effectively because they're relying on it for its accuracy. How does a lawyer provide adequate supervision when the lawyer does not understand how the work is being done or even who is doing it? That's problematic. Like I said, based on the platform that you're using, you have to understand how that information is being generated, how that work is being done, and you also have to understand how secure is it. All right. AI has a lot of implications when we talk about the rules of professional conduct. Um, how do you bill using AI? Again, it's all problematic because if you're billing at your regular rate, but it's taking you a fraction of the time, um, that's dishonest, essentially. You can't charge a client 3 hours for doing legal research when you did it in 5 minutes. All right. So these are just some of the rules that implicate the use of AI. Competency, that's huge. And I'll just turn to Rule 1.1 so that you can see. But lawyers are charged with providing competent representation, okay, to a client. Comment 8 is the one that speaks to a lawyer's use of relevant technology. If a lawyer is going to use technology, and let's say it's AI, in their practice, they have to make sure that they understand it. They have to comply with all the requirements that they are subject to. They have to understand essentially the benefits and the risks thereof. In some situations, lawyers have to get informed consent. Informed consent is defined under Rule 1.0, but they have to talk to their client and have a meaningful discussion so that the client understands what AI is and what AI will do and how the lawyer intends to use AI with regard to that representation. It does pose a huge risk. And so for that reason, lawyers are charged. If you're going to use technology in your practice, under comment 8, you are charged with knowing what those risks and benefits are, and then making the determination at that point. Now, the question has been posed, is it considered incompetent for a lawyer to not use AI? Maybe, okay? Maybe. It really all depends. But like I said, because it's just newer to the practice of law, I mean, AI has been around for a long time. LexisNexis, Westlaw. I mean, AI is almost in everything that we do. But when we talk about doing the actual work of a lawyer, I'm talking about the legal research, the writing aspect. You just have to be extremely careful. Additionally, another implication, confidentiality. All right. Some of these platforms are open. And in which case, if it's an open platform and you're putting your client's personal, confidential information into that platform, you don't know who has access to that. And you may not have gotten your client's permission to make those sort of revelations to an open online platform. Candor towards a tribunal, that's also an issue as well. Lawyers, and we've seen several examples of lawyers using AI where they were not candid to the court, and they didn't indicate in their pleadings that it was generated by AI. Now, we all use AI. Generative AI is fantastic, like I said, for a lot of different things. But when it comes to actually coming up with legal ideas and doing attorney work products, you have to be extremely careful. It's the sort of thing that if you need a jump start in thinking about an issue, you should already kind of know where you're going with that. In terms of tailoring, a writing better, maybe, but honestly, for me, I would just say lawyers should more than likely steer clear of using AI unless they are really clear on how it is that courts and different tribunals are expecting lawyers to use it. So, how courts are reacting to AI, you all have heard of the Mata case out of New York, Mata versus Avianca. This is the case. I mean, this was all over the news, but essentially these lawyers were citing to fake cases in their brief and they submitted to the court. When the court brought it to their attention that, you know, these cases had issues because the other side couldn't find these sources, the lawyers not, rather than say, oh, let me take a second look, they kind of doubled down on it. And it just, it just strikes me as very peculiar because they doubled down on it. And they said here in this quote, they couldn't believe that ChatGPT could create fake cases, which is never something good to say, because it just shows that they relied on that research improperly. They cited it verbatim. They didn't do the necessary gatekeeping that lawyers are required to do to ensure that anything that's filed with the court is truthful and accurate. So the lawyers in that case, they were sanctioned. The court sanctioned them with a $5,000 sanction jointly and severally. They were also required to write a letter to every client and every judge that they cited, because they cited judges with these fake cases and attributed those opinions to those judges. And they were required to write a letter to all of them just to let them know. Additionally, jurisdictions like the U.S. District Court in Texas and in Illinois and Pennsylvania, as well as the U.S. Court of International Trade, they do permit the use of AI only if it's disclosed. So, and some judges, like specific judges in different jurisdictions, have their own specific disclosure forms. So you want to make sure that if you're doing any sort of work before a federal court, that you double check to see what that federal judge might require. Additionally, in state court, it's also good to get some guidance on how state courts are viewing AI. Many jurisdictions have drafted kind of an AI policy or document, if you will. I know in Maryland, we have drafted an AI document so that lawyers can look at that document and get some guidance on what it is that is required. There's no certifications here in Maryland, but if I had to guess, it probably is coming. But you want to make sure that you certify the authenticity and the accuracy of any case that you cite in any pleading that you file with the court. All right, this case too, Gauthier versus Goodyear. This is a case out of Texas. This was a case also where these lawyers, they cited cases that essentially didn't exist, and they had several quotation marks for their fake cited authority. And a show cause order was issued. They had a hearing whereby the attorney, essentially admitted to using this AI tool to produce this document. And so the lawyers kind of made it worse because they didn't take any action. Anytime that the court brings it to your attention that there's an issue with citations that cannot be found, the best thing for the lawyer to have done at that point would have been to go back, look at those cases to determine, oh, wow, they actually don't exist, and to try to request court permission to file a responsive pleading that is accurate. I mean, it would have made so much better sense for the lawyer to come back with a well-written brief with correct citations and just ask for permission. Now, it's up to the court to determine whether they're going to grant that permission or not, since at that point it may have been out of time. But better to do that than to rely on a document that essentially, for all intents and purposes, is considered inaccurate due to these fake cases. So in the Gauthier case, the court ordered the attorney to pay a $2,000 penalty, and they also required the lawyer to take a CLE on the use of AI. And so I kind of ran through all the material because I wanted to make sure that we had enough time for questions. This is essentially the last slide, but those are all the slides. I'll look to the Q&A to see. I think we have a few more questions.
We can now go ahead and move on to those questions. If you do have any that you haven't input quite yet, you can go ahead and click the Q&A button in the control panel at the bottom of your screen and send them in there. Looks like we already have a couple, so feel free to go through them.
All right, so the first, it says, can you charge for those services up front? If I recall, I think this is the situation where the lawyer wanted to charge for an in-person video consult. Lawyers are permitted to charge for consultations. The issue is timing. If you collect the funds upfront before the consultation occurs, that's not earned because the consultation didn't occur. That has to go in trust, okay? At the point in time that the consultation has concluded, you have done everything that you were hired to do, which is to have that consult. And after the conclusion, you can then pay yourself and move the funds from trust to your operating or your personal account. All right, so the next one, so I think it just needs to start in the IOLTA, but that means you need to have an IOLTA set up for consultation before you know if you will take the case. Correct. So you have to have a trust account because you can't put a client funds or entrusted funds in your own account, right? That's considered commingling, and that could warrant a 6-month suspension. So you want to make sure that you don't do anything that will affect your license, or find yourself in a position where you can't practice law because you didn't have the correct accounts in place. All right, so the last point of all right, I've heard experienced lawyers and students who flippantly disregard social media as non-evident and sensationalized. However, social media shows video evidence of victims who are harmed physically, emotionally, etc. Your thoughts? Social media, I mean, I think there was a time when it first started, people didn't take social media seriously. I think now, though, social media is so prevalent in just our everyday lives. Everyone has social media. Judges have social media. Attorneys have social media. Your clients have social media. Victims have social media. Social media actually is a wealthy area for evidence. I can't tell you how often I am looking at screenshots of DM messages, things that are posted, things people are posting about other people, things that, the client might post, a witness might post. Those are all considered relevant information and evidence. So, and social media, honestly, I think it's here to stay. I think there was a point in time earlier, in the late 2000s where people, didn't take it seriously. And it was like, if you're a lawyer, you probably shouldn't be on social media. But the truth is, everyone's on it now. We're in 2025. Social media is a great place to gather evidence. And that's what people are doing. Not just lawyers. I mean, but think about it. I mean, and your example, evidence of victims who are harmed physically. Think about the other side. Insurance companies are looking at social media. If you're a victim and you claim you've been harmed, but you're posting a picture of you bungee jumping, that's something that insurance companies want. And I can't tell you how many cases where it comes up that the person, posted themselves there was a case that came out earlier this year, the woman with the Christmas tree throwing contest, where she was throwing Christmas trees, but she was out of work for a year on a workers' comp case and couldn't work due to her injuries to her back or her neck. I mean, that is a wealthy place for evidence. So yes, I think social media is here to stay. It's a good place to gather evidence. So during the outset of the representation, when you have that initial meeting with your client, that's when you should talk to them about their social media. Talk to them about what it is that they're posting. And I am no way saying that you should have them go back and scrub their page, okay? That you can't do. But just have them be more mindful, because everyone's looking at social media, even when you think your account is private and no one can see it, but you and your 100 friends, people can see it. All right, how can I convince my jurisdiction that we need an AI policy? Oh, fantastic. My thought would be go to the Supreme Court or the Court of Appeals, whatever the highest court is. They're the ones generally that will take a look at the things that need to be done with regard to guidance. And you might even be able to go to the ABA. The ABA has a ton of resources, but the ABA typically are the ones that start the kind of research, if you will, about these areas that are gaining traction in the legal profession. And take that. You can take it to your Supreme Court. You can certainly take it to your disciplinary body. It could be the Attorney Grievance Commission or whatever the Office of Disciplinary Counsel is, and just let them know, hey, listen, there's this use of AI. There are all these cases coming out. And I just talked to you about 2 cases, but there are a number of cases that are still coming out where lawyers don't know how to use AI. They don't have enough guidance, unfortunately. I mean, some of the guidance is obvious, check your work. Okay, you're going to file it with court. You should read it. You should check it. You should ensure that all the citations are correct. But my suggestion is to perhaps either go to the Supreme Court, go to the Rules Committee. Many jurisdictions have a Rules Committee. So whoever's that body that deals with kind of initiating rules that should come before the court, go to them. If you are part of that bar association, if it's mandatory or voluntary, go to the bar association and say, hey, listen, what's going on in the world of AI? What should happen? Because typically, if you're thinking about it, other people in your jurisdiction are as well. How should I communicate the use of AI tools to clients clearly and effectively, ensuring they understand both the benefits? That's a lot. So I can't give you that answer. But what you might want to do is look at some of the papers that have been published on the use of AI. Because essentially, if you're going to get the client's informed consent, you have to go through all the risks. Okay. And I listed in the PowerPoint all the rules that are implicated. The 1.1, the 1.5. Essentially, you want to go through the parade of horribles so the client understands and the client signs off and says, notwithstanding that, it's still okay. All right. Additionally, 1.6, confidentiality. Is the client okay with you putting their information online? Right. And depending on the matter, like let's say you work for Google. I mean, that would absolutely not be okay. Right. You'd probably have to go through a closed platform because, Google wants to keep secret all their codes and all the things that they're doing. So this might just be a good time for you to either consult with like a law practice management group. Lots of jurisdictions have them. Depending on your bar association, just go to see what they recommend because there are so many. And like I could have listed, but there are so many legal platforms that lawyers are using for AI. Like, we just kind of talk about the general ChatGPT, but I mean, ChatGPT is nothing. There are like dozens and dozens and dozens and dozens of them. So you just want to make sure that you kind of go through all the information about them, think about what it is that your clients need, and then you can determine what is the best course of action. All right. And get them to sign off on it. Great question. All right. So a junior lawyer at my firm is using AI for first draft. First drafts. That's terrible. That is absolutely terrible. And I'm going to say this, and I'm probably going to date myself. But, when I went to law school, we had to learn everything, research and write on the books. Like we had to go to the law library, pull out the books. And then, after we learned how to do all that stuff by the books, we then got, LexisNexis password, Westlaw password. But you had to learn how to do it first. So if they're using that for the first draft, that's terribly disappointing. What I would suggest, like I said, I don't think it's a good idea because what AI does is it's limited to what it knows. AI is not a lawyer. Okay. The junior lawyer is a lawyer. You're a lawyer. You know what it is that the lawyer should be thinking about, the issues involved with that client's matter. AI is kind of limited to its own scope. All right. It only has the information that it knows. So I would talk to, and I didn't see the rest of the question, but I would just talk to that junior lawyer to let them know that's not acceptable. When you go to law school, you learn how to lawyer. Okay. And so it's important for a lawyer to use their own professional judgment first. Okay. Once you got that down, once you got something on paper, if you want to make it pretty, that's different. But in terms of the first draft, that's really limiting. And unfortunately, it's letting AI be the lawyer. And that is not what AI is designed for, not for lawyers. What are practical strategies for managing client expectations about response times, deliverables? So here's the thing. It all depends on your practice. But it's the type of thing that you should put in writing. You should definitely put in the fee agreement. And it depends on the nature of the work that you're doing for the client. If it's something where it's kind of expected there's a fast turnaround, then you can frame that and let them know, hey, within I'm just saying hypothetically, a week. You should be able to get, we'll have this document ready for your review. Especially when AI tools are used, again, this is the 1.0 informed consent conversation you're going to have with the client, because if you are using AI, the client has to be okay with that. They have to sign off on it. They have to say, okay, I'm okay with the 1.6 possible breach of confidentiality and the 1.1 and the 1.3. They have to be okay with all of that. And then again, you just kind of have to base what it is that you were hired to do and what AI is going to do, and just determine what is considered a good, reasonable amount of time to turn that around. What are the laws you think are needed to facilitate the use of AI by lawyers? Well, so here's the thing. I think 1.1 kind of sums it up nicely. All right. Lawyers are charged with providing competent representation. Competent representation that embodies the proper legal skill, thoroughness, and preparation. Lawyers have to do all three things. They're not just in a vacuum. If you're going to do those three things and you're going to rely on AI to do those things for you, that's where the problem arises. That's where we see pleadings that are drafted by, robots, if you will, where lawyers are not looking at it and thinking about, oh, does this argument make sense? Or is this clear? Or is this not? You can't leave it up to AI to do the work. Now, AI is good at doing some things. They're great at kind of collating lots of evidence and documents and summarizing things. But in terms of like initial drafts of things and documents and pleadings, I think it's just very problematic. So to answer your question, rule 1.1, I think that's the only rule that I think really speaks clearly to the use of AI in Comment 8. If AI reduces drafting or research time, how should fee agreements or billing reflect that? Great question. So here's the thing. I can't really answer that, but it is certainly the type of thing that other lawyers in your area know. Like I said, you can't bill a client for 3 hours when it didn't take you 3 hours, but you have to figure out what that looks like. What was your time? Even if AI, drafted it or made it pretty, you still have to look at it for its accuracy. How much time did it take for you to review it? If AI mentions cases that you were otherwise not familiar with, you got to look up those cases. You have to read those cases. You have to make sure that whatever the cases that were cited are consistent with whatever argument you're making. And in which case, how long is it going to take you to do that? So, it really just depends. I can't really sit here and say, because it's kind of giving you legal advice and I'm prohibited from doing that. But those are the kinds of considerations that you want to take into account. How much time is it taking you to get that pleading, that document, that whatever, into good enough shape that you can turn it out and give it to a client or opposing counsel or the court or whoever? And like I said, if AI is doing some of that in, a third of the time, then that savings should be passed on to the client. You can't charge the client for the full work when it didn't take you as much time. Because if you do, and the client comes to learn of it, then you have an 8.4C issue, you have a 1.5 issue where you were overbilling. And I've seen lots of horrible overbilling cases where lawyers are like, oh, it took me 18 hours to do this, and it didn't. Because they were able to do it really quickly. And you don't want to be charged with dishonesty. In some jurisdictions, if you're charged with dishonesty and you're found to have engaged in dishonest conduct, that's a disbarment. Okay. So those are all great questions. Really great questions. This is a great crowd.
Thank you so much for answering all of those questions and giving us your insights throughout the presentation and during the Q&A. And thank you to all of our participants today for asking those questions. We really appreciate your activity and your participation in today's event. We want to thank you so much for joining us for another Justia webinar. Before you go, don't forget that Justia Connect Pro gives you access to the CLE credit opportunities through live and on-demand webinars just like this one, so you can stay informed and compliant. You will also get access to other benefits like an enhanced Justia Lawyer Directory profile, the AI-powered Justia chat to help you get more leads, and exclusive discounts on Justia marketing solutions. If you'd like to learn more, you can go to pro.justia.com. Thank you all so much for your time and have a wonderful rest of your day. Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.